Good evening to one and all. And especially as a lawyer, we have seen that sometimes we draft on the basis of a law as on that date. And during the flux of time, we find that the law has changed. Then what is the effect of change in law as to how it will affect the pending cases? Is a topic which we discuss day in and day out. And we thought, why not ask Mr. S. Srinivasa Raghavan, an advocate from Madurai Bench and the former president of the Madurai Bench, to share his knowledge, because I would also share that we also had done one case as such, wherein we had challenged that in respect of the B.Ed candidates under the rules ought not to be ousted for the post of elementary trained teachers course. We had a stay in our favor. The rules were at that point in our favor. But eventually, their judgment came that B.Ed could not teach the primary students. Okay. And it was also held therein that it will only affect, it will protect the persons who had already stood appointed and no one else. So that is the dilemma and how the law should travel and what can be the powers in this Article 142, wherein in substantial justice we have been doing it, even though, like we have seen this latest judgment of Sivanandan CT, wherein the district judges were saved on the ground that though the selection is not in consonance with the settled principles of rules of the game cannot be changed. So much so. Rather, I will request Mr. Raghavan to take over rather than my speaking and posing as if the session is mine. Over to Mr. Raghavan.
Thank you, Mr. Vikas. Am I audible? The audio is okay? Okay, fine. Good evening, everybody. The topic of the day has got relevance not only to lawyers in the higher echelons of the society, it is relevant for the lawyers in the advocates in the lowest strata of the courts. Since the subject has been debatable and there are a lot of judgments ruling the roost, I thought fit of taking this for deliberations today. Effect of change in law affecting pending cases is the topic. As we know well, the law is not a body which is not undergoing any change. It keeps on changing, keeping pace with the changing phase of the world, science, technology, etc. So the change of law will have a bearing in pending cases most of the times. A single amendment of a provision of law may have a devastating effect on a number of cases at one strike of the pen. This is what we are going to deal with today and what is meant by this session. There are a lot of judgments ranging from the full bench of the Supreme Court and 3 judges bench strength of the Supreme Court, a regular bench, and some high courts. So I may confine myself only to 6 or 7 cases and come to finally the latest judgment of Supreme Court in the year 2023. See, the requirement of this section of the lecture series to understand the permissibility of the courts, whether it is in the trial stage or in the appellate stage, to take stock of the change in law. And the courts are duty bound to reflect the change in law in their judgments, either in the trial stage or in the appellate stage, is the matter for consideration today. You may be aware that the changes of law may affect pending cases mostly. The first and foremost case law I want to take for discussion is the judgment of the Supreme Court of India, rendered in the year 1966. It's a case called Dayavati and another versus Indrajit and another. Dayavati and another versus Indrajit and another. And it is reported in AR 1966 Supreme Court, page 1423. So the Supreme Court, after discussing the subject matter, that is the change of law. The change of law was the Punjab Relief and Indebtedness Act 1934 and an amendment thereon. While dealing with the applicability of the change in law in the pending cases, the Supreme Court had constituted a bench of 3 judges and the law was laid down. It says, if a new law speaks in language which expressly or by clear intent takes in even pending matters, it's very important, by clear intent takes in even pending matters, the court of trial as well as the court of appeal must have regard to an intention so expressed. I repeat, if a new law speaks in language which expressly or by clear intent takes in even pending matters, the court of trial as well as the court of appeal must have regard to an intention so expressed. And the court of appeal should give effect to such a law even after the judgment of the court of first instance. In other words, assuming a judgment has been delivered by the trial court, thereafter an amendment is brought into force, and the amendment is going to alter the situation that was the subject matter of decree by the trial court. Now, the question posed is whether the court of first appeal is to take into account the change of law, the change in law, while dealing with the appeal. The Supreme Court in the said judgment has discussed this issue in a short but very effective judgment, and more particularly, para 10 is relevant. In para 10, the court says as follows: as a general proposition, it may be admitted that ordinarily a court of appeal cannot take into a new law brought into existence after the judgment in question has been pronounced, because the rights of the litigants in an appeal are determined under the law that was in force during the trial. So the basic fundamental principle is that once the law is administered as it stood applicable during the trial or during the pendency of the suit, normally the court of appeal is not supposed to take stock of the change in law. But there is one exception that is called retrospective operation of the law. And we all know the basic tenets of law. All acts are prospective and all judgments are retrospective unless the contra intention is intended in the act or judgment itself. If the acts are meant to be retrospective, there should be a specific provision in the act saying that the change of law will apply to pending cases also. You could have seen this in a lot of cases. Similarly, if a judgment is said to be not retrospective, it is made applicable only from a particular date. It is called prospective overruling, and only the Supreme Court of India has got powers under Article 142 of the Constitution of India. So the general rule is that unless and until the law is made retrospective by clear intention expressed in the provision itself, it cannot be applied to pending cases. But the Supreme Court has reiterated in the said case that if it is a procedural law, it must be deemed to be retrospective, even in the absence of any such expression. And when there is a provision in the enactment stating that the change in law will be applicable to pending suits, the Court of Appeal should take into account the change in law, and the new law should be applicable, though in the trial stage and totally opposite legal position was applied. This has been very clearly expressed by the Supreme Court in the said case called Dayapati versus Indrajit. If we go further, I would like to refer a judgment of the Supreme Court of India in the year 1974 in a case called Amarjit Kaur versus Preetham Singh and another. Amarjit Kaur versus Preetham Singh and others, reported in 1974 Volume 2, Supreme Court Cases, page 363, 1974, Volume 2, SEC, page 363. This is a batch of cases. The judgment has got only 6 paragraphs. Very crisp, but very effective judgment. It says, by taking into account the scope and ambit of sections 96, 100, and 101 of CPC, the Supreme Court has defined what is an appeal, what is the nature of an appeal, and whether the appellate courts are entitled to take into account facts and events coming into existence after passing of the decree which is under challenge. In this said case, the Supreme Court has categorically held in para 4 of the judgment. It's a case coming from the Punjab and Haryana High Court, and the subject matter of the dispute was an amendment in section 3 of the Punjab Preemption Repeal Act 1973. So the said section clearly stated, on and from the date of commencement of the Punjab Preemption Repeal Act 1973, no court shall pass a decree in the suit for preemption. So by a change in law from a particular date, the decree to be passed in a suit for preemption has been totally repealed and taken away. So while dealing with this matter, in para 4 of the judgment, the Supreme Court has discussed the law in clearest terms by referring to 2 judgments of the year 1902 and 1940. The case of the Privy Council reported in 1940, FCR, it must be the federal court, FCR, page 84. Lacheshwar Prasad Shakul versus Keshwar Lal Chaudhary. In this case, the federal court has taken into account the applicability of the change in law in the appellate proceedings. The said federal court judgment has followed a judgment of the Madras High Court reported in the year 1902. It's a case between Krishnamacharya versus Mangammal, reported in 1902. Indian Law Reports, Madras, page 91. In this said case, the Madras High Court has held in unequivocal terms that hearing of an appeal is under the procedural of the country. I repeat, hearing of an appeal is under the procedural law of this country. It is in the nature of rehearing, and the courts in the country have in numerous cases recognized that in molding the relief to be granted in a case on appeal, the Court of Appeal is entitled to take into account even facts and events which have come into existence after the decree appealed against. So the Madras High Court has ruled in the year 1902, based on the previous practice and law, that a Court of Appeal is duty bound to take into account even facts and events which have come into existence after the decree appealed against. This judgment in Krishnamacharya's case rendered by the Madras High Court in 1902 has been followed by the federal court in the year 1940, as reported in Lacheshwar Prasad case, where it is once again reiterated that a Court of Appeal shall have the same powers and shall perform nearly the same duties as are conferred and imposed by the CPC on the courts of original jurisdiction. So any change in law after the trial and judgment, which is retrospective in operation as per the expression provided, the courts are bound to take into account the change in law. So this judgment in Amarjit Kaur's case has traced the march of law from the year 1902 onwards. Again, another judgment I want to cite is of the year 1985. This is a case between Lakshmi Narayan and others versus Niranjan Modak. Lakshmi Narayan and others versus Niranjan Modak. This is a case with relating to West Bengal Premises Tenancy Act 1956, in which there was an amendment in section 13(1) and section 6. So in this judgment, the Supreme Court has held that the doctrine of merger has got an application. You know very well, once a judgment is passed by the appellate court, the judgment of the appellate court and the judgment of the trial court will merge with each other. By applying the doctrine of merging, the Supreme Court has clearly held in the said case, in para number 8 of the said judgment, it says, whether a statutory injunction of that nature could be applied retrospectively to appeals against decrees or not, the court said in the affirmative. It says, an appeal was a continuation of the suit, and that the appeal would be governed by the newly enacted clause of the particular provision of law, even though the trial court decree has been passed earlier. So in the said case, the amendment was brought into by West Bengal after the decree has been passed in the suit and during the pendency of the appeal. Then the Supreme Court has held that because of the nature of the amendment, which is made applicable to pending suits and appeals, the said change of law or change in law that has been brought into force after the disposal of the suit and during the pendency of the appeal should be taken into account by the appellate court. This judgment of the Supreme Court of India of the year 1985 traces its strength to the full bench judgment of the Supreme Court of India of the year 1963. In the year 1963, a full bench was constituted with 5 judges of Supreme Court to deal with an amendment in the Punjab state. Again, it was the amendment of the Punjab Preemption Act 1 of 1913. So the Act, Punjab Preemption Act 1913, was amended in the year 1960. So the constitutional validity of the said amendment was put into challenge, and a larger bench of 5 judges was constituted, and the said judgment was rendered on 30th August 1962 by the larger bench. It is reported in a case called Ram Sarup and others versus Munshi. Ram Sarup and others versus Munshi. And it is reported in AAR 1963 Supreme Court, page 553. AAR 1963 Supreme Court, 553. This judgment has got 2 parts. The first part of the judgment speaks about the constitutional validity of the said amendment. It was challenged under the garb of violation of Article 19(5) of the Constitution of India, stating that it lacks reasonableness, but rejecting the challenge posed to the said amendment and upholding the amendment as constitutionally valid, the Supreme Court of India proceeded further in terms of applicability of the change in law in the proceedings pending before the Court of Appeal. After a full-fledged discussion, the judgments run into really more than 15 pages, and it has got nearly 28 paragraphs. Most apt paragraphs which deal with the subject on hand is paragraphs number 25 to 29. In paragraph 26, the Supreme Court, through its constitutional bench, has discussed the scope and ambit of the amendment and said that section 31 of the said act, the amending act, says as follows: no court shall pass a decree in a suit for preemption, whether instituted before or after the commencement of the Punjab Preemption Amendment Act 1959, which is inconsistent with the provisions of the said act. So there was a provision in the amending act itself that clearly prohibits the court to pass a decree in a suit for preemption, thereby upholding the preemption. So the preemption right has been repealed by an act of parliament, which has been upheld to be a valid law. And then the Supreme Court says, while this being the case, the change in law should be taken into account by the courts across the country, and hence no pending suit granting such a preemption decree, and no appeal provides for such preemption decree should be passed. So the said change in law was given effect into by the Supreme Court through its constitutional bench in pending suits and pending appeals also. This judgment has been followed by almost all the courts across the country whenever the question of applicability of change in law is taken into consideration. In fact, the judgment I referred to in the year 1940 by the Federal Court of India was also followed by the Constitutional Bench. It is there in para number 27. The court has followed the Federal Court judgment reported in AR 1941 Federal Court page 5. AR 1941 Federal Court page 5 equivalent to 1940 Federal Court reports page 84. The Supreme Court says, in the said case, the learned counsel for the appellant relied fully covers the case. The question there raised related to the duty of the federal court when an amending act enacted after the decree appealed from was passed adversely interfered with the rights of the respondent before the Court of Appeal. The learned judges in the federal court held that the provisions of the act were clearly retrospective and should be applied to the decree which was the subject matter of appeal before it, and the appeal was accordingly allowed. So the net result of the judgment of the Constitutional Bench was this. Even before the Federal Court of the year 1940, when a change of law is contemplated and when the provision is made retrospective, such a change in law should be taken into account by the court while disposing of the appeal, and even in the trial court when there is a provision to that effect. So this judgment of the full bench of the Supreme Court of India of the year 1963 proved to be the cynosure for all the cases to follow. Again, in the year 1969, another occasion came before the Supreme Court to deal with the matter. That is the case called Mula and others, M-U-L-A, Mula and others versus Godu, G-O-D-H-U and others, Mula and others versus Godu and others, reported in 1969, Volume 2, Supreme Court Cases, page 653. 1969, Volume 2, Supreme Court Cases, 653. Again also, the judgment of the court revolves around the amendment relating to Punjab Preemption Amendment Act 10 of 1960. Again, Section 31 of the Act was considered, and we have already seen that the same Act has been upheld and the law has been declared by the Supreme Court. And again, the same view has been reiterated by the Supreme Court in 1969 to SEC, page 653 in Mula's case. Now, the question that arises for consideration again is that whether any change of law has occurred thereafter. I would say it in the negative. The only distinction is, no doubt, when the provision being applied is procedural, and there is an amendment to the procedural law, and there is a transitory provision or a provision which says that the amendment will apply to pending cases, whether it is in the trial stage or in the appellate stage. We have no doubt umpteen number of cases from 1902 till 1969 that such a change in law should be taken into account by the courts concerned across the country. Again, I repeat that emphasis is applied for the fact that the change in law is taken into account because there is an amendment in the procedural law which is held to be or said to be or mentioned to be retrospective in operation. In other words, there must be a provision in the enactment or the amending act that makes it very clear that the change in law should be applied to pending cases by a specific provision in the amending act. So when the amending act has got a provision which says that the amendment will have effect on the pending cases, whether it is in the trial court or in the court of appeal, and there are judgments to say that when it is relating to the procedural laws, the law has been settled well from the constitutional bench till the regular bench, that such a change in law should be taken into account. Now your question may arise, what happens if there is a change in the substantive law, or when there is no provision of retrospective operation? And what is the position of law when a particular class of suits are held to be barred, to be outside the scope of the civil courts? For example, I will take into account an act called Recovery of Debts Due to Banks and Financial Institutions Act 1993. That is a 1993 Act, Recovery of Debts Due to Banks and Financial Institutions Act 1993. In this act, there are two sections, sections 18 and section 31. These two sections clearly bar the jurisdiction of the civil courts, and rather it paves way for transfer of pending cases to DRT, Debts Recovery Tribunal. This is what we call as a transitory provision. It happens in a lot of cases. We can see the same in Commercial Disputes Act, but it is transferred from a regular civil court to commercial division. It happens in SURFACE Act. So whenever there is a special act and special courts are being formed, pending cases are transferred when there is a transitory provision. When such an act was passed in the year 1993, the same was a subject matter of a dispute, and the case came up before the Supreme Court in the year 2000. This is a case between United Bank of India, Calcutta versus Abhijit D. Company. Abhijit T. Company. It is called Abhijit T. case. United Bank of India, Calcutta versus Abhijit T. Company Private Limited. Reported in 2000, year 2000, volume 7, Supreme Court cases, page 357. 2000, volume 7, SEC, page 357, in a case called Abhijit T. Company case between United Bank of India, Calcutta versus Abhijit T. Company. In the said case, it is an elaborate judgment where the Supreme Court has considered the length and breadth of the point in dispute. There are two important provisions in the Act, namely Section 18 and 31. Section 18 of the 1993 Act speaks of bar of jurisdiction. That means after the Act has come into force, no civil courts have got any right to entertain any suits filed by the banks for recovery of debts from individuals. So that is the bar of jurisdiction. From that day onwards, the civil courts will have no jurisdiction to try such suits. And Section 31 speaks of transfer of such suits from the file of the civil courts concerned to the DRT. DRT is the special court under the said Act. This is called a transitory provision. While dealing with both the sections, the court says the change in law that took place after the trial court has taken up the trial and during the pendency of the suit as well, and during the pendency of the appeal against any such decree as well, the courts will lose its jurisdiction. And the court of trial and the court of appeal should take into account the change in law and should not try any suits thereafter. The said judgment, which runs for nearly 46 paragraphs, clearly upholds the principle stating that irrespective of whether it is a substantive law or procedural law, irrespective of availability of a transitory provision or a provision for application of the provision or the change in law to a pending suits or not, whenever there is a change in law which is going to take away the jurisdiction of the civil court or a new law has been enacted, the courts are duty bound to apply the change in law to its existing or pending judicial actions. This judgment of Supreme Court of India in the year 2000, volume 7, SEC is 357, is not confined to any act which is said to be procedural. It speaks of a substantive law also, but there are two provisions which make it very clear. Number one, barring the jurisdiction of the civil courts that was hitherto enjoyed by the courts till the act was passed, and paving way for transfer of pending cases from the file of the civil courts to the DRT, Debts Recovery Tribunal. Because of the availability of these two provisions of law, the Supreme Court says the court of trial should take into account the change in law and transfer all the cases to the DRT. And because of the change in law, whereby the suits are barred, no appeals can be heard, because though the law in force when the judgment was delivered in the suit was in favor of conferring jurisdiction to the trial court, because of the change in law, the jurisdiction is taken away. Even pending appeals should not be disposed of. They should be tried only by the DREAT. So this change of law should be taken into account by the courts across the country, is clearly spelled out by the Supreme Court in the year 2000, which is not necessarily a procedural law. It may be a substantive law also. So now the message is very clear. When there is an amendment in the procedural law, whether it is made retrospective or not, it can be followed for pending cases also, or rather any such change in law in procedural enactment should be given effect for pending cases, whether in the trial state or in the appellate stage. Number one. Number two, when there is an amendment of any particular enactment, and there is a provision in the said enactment stating that the amendment shall apply to all the pending cases and appeals, here also, the change in law should be taken effect and it should be applied by the courts across the country, whether it is a trial court or the court of appeal. The third development is, even in substantive law, when there is a change, for example, when the change in law results in jurisdiction of the courts being taken away, or the pending suits are transferred to some other special forum created by the Act, the Supreme Court says such a change in law should be taken into account by the trial court as well as the court of appeal. These three things are very clear from the said judgments. Now we have to go through the power of the Supreme Court. This is exclusively available under Article 142, as I already referred to earlier. This Article 142 is something very unique to the Indian Constitution that makes the Supreme Court of India as the most powerful courts across the world. So this Article 142 will not say that in very clear terms that what is the power of the court. It only speaks of a mode in which the Supreme Court is authorized to pass orders to enforce the judgments throughout the country in an effective manner. The first and foremost occasion, and for the first time, Article 142 was expressly applied by the Supreme Court of India. You will be surprised that is a case where it is a Bhopal gas disaster case. It was in the year 1989. It is called Union Carbide versus Union of India, reported in 1989, Volume 1, SEC, page 674. Union Carbide versus Union of India. You may know that there was a huge disaster, caused a lot of loss of life and irreparable health hazards. And you would have either seen the television serial in Netflix called The Railwayman. So this case was pending before the trial court for compensation. And by using Article 142 of the Constitution of India, the Supreme Court has transferred all the cases to its file and has reached a compromise or an undertaking with the Union Carbide, thereby paving way for settlement of dues at the earliest opportunity. This is the earliest occasion Article 142 was used by the Supreme Court, by making it widely known to everybody. The second case, which is notably a case where the Supreme Court applied Article 142, is A.R. Antule's case. It's called R.S. Nayak versus A.R. Antule, which is reported in 1984, Volume 2, Supreme Court Cases, page 183. It was a case where an expeditious trial was ordered as a special case regarding corruption charges. And the cases pending before the Sessions Court or special courts were withdrawn and transferred to the High Court at Bombay, and it was tried there. This order was under Article 142 of the Constitution of India. The second case where Article 142 was applied by the Supreme Court. Third is the very important case called Vinay Chand Mishra's case. Vinay Chand Mishra's case was of the year 1961. It is called V. Sri Mishra, reported in 1995, Volume 2 SEC, page 584. V.C. Mishra, 1995, Volume 2 SEC, page 584. Is a case where a person was convicted for contempt of court act. At the same time, his license to practice in the court was also withdrawn. This was also under Article 142 of the Constitution of India. And a very famous case under Article 142 is the Supreme Court Bar Association case in the year 1998. The SCBA versus Union of India, reported in 1998, Volume 3 SEC, page 184. 1998, Volume 3 SEC, page 184, SCBA versus Union of India. Here is the case. The Constitutional Bench of the Supreme Court of India has, for the first time, has curtailed its own power while exercising Article 142. It's held that while exercising the power under Article 142, the court should not ignore the substantive rights of a litigant under the existing law. This is very important. So the impression that Article 142 is omnipotent was whittled down by the Supreme Court itself by stating that while exercising this power under Article 142, the Supreme Court should not ignore the substantive rights of a litigant under the existing law. I may instantly remember a case referred by Justice Markandeya Kajju, what's called a Parvadaneni's case. Under Article 142, the Supreme Court started issuing directions in a lot of cases. But Justice Kajju was having a doubt. When a statute does not provide for a particular remedy, or a remedy which is not confined to the parameters of a particular law or a statute, can still the Supreme Court give a relief outside the scope of the particular act? That was the point for reference raised by Justice Markandeya Kajju. It is called the Parvadaneni's case. But what happened subsequently? A bench was constituted, a larger bench was constituted, but the Supreme Court refused to give any findings stating that we will see the issue as and when appropriate case comes before us. So a golden chance of deciding whether Article 142 can be used to give a relief which is not covered or contemplated by a statute or outside the parameters of law has not been delivered so far, and it is to be seen for the days to come to say. And under Article 142, we all know the Supreme Court has got enough powers to make a particular judgment enforceable in a particular way. That includes making a judgment prospectively operative and transferring any case and conferring jurisdiction upon a thing which it does not even have. So this is the power of the Supreme Court, Article 142. So this can be exercised only by the Supreme Court. Now, an important development has happened in the year 2023. This is under Section 6 of the Hindu Succession Act. We all know in the year 2020, a landmark judgment was delivered by the Supreme Court of India under Section 6 of the Hindu Succession Act, what is called a Vinita Sharma's case. This is a landmark case that has settled the lot of doubts that has crept in the subject. Vinita Sharma versus Rakesh Sharma, reported in year 2020, Volume 9, Supreme Court Cases, page 1. Vinita Sharma versus Rakesh Sharma, year 2020, Volume 9, Supreme Court Cases, page 1. We are not on Vinita Sharma's case now. A case has come before the Supreme Court where an interesting point has been raised, and this has been answered by the Supreme Court in 2023. A case before the trial court was filed by a daughter against her brothers for partition. She claimed that the properties are ancestral properties of her father, and she has got undivided equal one-third share on par with her sons. When the brothers collided and refused a share to her, she moved the trial court for a suit for partition. The trial court has decreed the suit by dividing the partitioned properties into two parts. First schedule deals with ancestral properties or co-personary properties of her father. Second schedule pertains to the self-acquired properties of father who died intestate. So in the self-acquired properties of her father, since he died intestate, the court has given equal share, 1/3 share. In the ancestral properties of father, it was in the year 1980s the suit was filed. The judgment was delivered before 2020. So only 1/6 was given to her because the law in force at that time did not contemplate equal share for a daughter when the father was alive. That was the change of law only that has come into subsequently. So the court has given only 1/6 share in the ancestral properties for the daughter and 1/3 share in the self-acquired properties of the father to the daughter. Please bear in mind that it was not the daughter who filed the appeal before the High Court. It was the son, the brother, who filed the appeal before the High Court single bench, stating that all the properties are ancestral and co-personary. So she shouldn't have been given 1/3 share in Schedule 2 properties, treating the same to be self-acquired properties. During pendency of the appeal, two brothers have collided and one brother has purchased the share of the another brother. The single bench of the High Court has confirmed the decree of the trial court just by modifying the share of the brother because of the purchase of share by one brother from the another brother. Again, the brother moved the division bench of the High Court. Intra-court appeal was permitted then, challenging the same finding, stating that all the properties are ancestral properties, so the daughter should not have been given 1/3 share in the Schedule 2. The appeal was dismissed. Once again, the same brother has moved the Supreme Court. By the time when the Supreme Court was seized of the matter, the judgment in the Vinita Sharma's case came into force. So the law has been changed. What was the position of law when the trial court has disposed of the suit was totally different from what was the law as per judgment of Supreme Court of India post Vinita Sharma's case. So we can just take note of the thing that there was a change in law when the appeal was pending before the Supreme Court. So the said case is reported in the year 2023, volume 9 Supreme Court cases, page 641. 2023 year, volume 9 Supreme Court cases, page 641, in a case called Prasanta Kumar Sahu and others versus Charulata Sahu and others. Prasanta Kumar Sahu and others versus Charulata Sahu and others, reported in 2023, volume 9 SEC, page 641. In the said judgment, some para number 78, para number 79, para number 81, and para number 82 are relevant. Paragraphs number 78, 79, 81, and 82 are relevant. In the said case, the Supreme Court has framed a point for consideration while deciding the appeal. The point number 2 for consideration before the Supreme Court was this: when law governing parties in a partition suit has been amended before the conclusion of the final degree proceedings, whether the same can be considered and applied by the court or not. This is the second point for consideration by the Supreme Court while dealing with the appeal. Whether when law governing parties in a partition suit has been amended before conclusion of final degree proceedings, same can be considered and applied by the court or not. This is the point before the Supreme Court. The Supreme Court has decided the matter, stating that the court, whether it is of the trial stage or the court of appeal, should take into account the change in law without any second thought. This has been clearly held by the Supreme Court in the said paragraphs I stated. The Supreme Court says, when law governing parties has been amended before conclusion of the final degree proceedings, the same must be considered and appropriately applied by the courts. The suit was for partition, and the Supreme Court has held clearly that a suit for partition does not come to an end after the passing of the preliminary decree, because the argument put forth by the counsel was that once the preliminary decree is passed, the shares are ascertained. Thereafter, what is being done by the court in final degree is only allotment of the share on ground by means and bounds. So the preliminary degree has attained finality. A suit for partition becomes a final one on the advent of the passing of preliminary degree. But the Supreme Court says no and held that in a suit for partition, the finality is achieved only when the final degree is passed. So until and unless the final degree is passed, the suit for partition does not come into a grinding halt or an end, and hence the court should take into account the change in law even during the pendency of the appellate proceedings. The Supreme Court said, as partition suit is required to be decided in stages, as partition suit is to be decided in stages, same can be regarded as fully and completely decided. The suit for partition can be held and regarded to be fully and completely decided only when the final decree is passed. The court says it is the duty of a court. It is the duty of the court, whether it is trying original proceedings or hearing an appeal, to take notice of change in law affecting pending actions. It is the duty of the court, whether it is trying original proceedings or hearing an appeal, to take notice of change in law affecting pending actions and to give effect to the same in accordance with the law. So this is the judgment of the Supreme Court of India delivered in the year 2023 in a case called Prashanta Kumar Sahu versus Charulata Sahu. Now, the court has not gone into the issue whether the change in law is substantive or procedural, because this change in law is the aftermath or the result of the declaration of law by the court itself. It is not an amendment. The change in law is on account of the interpretation of the law by the Supreme Court by a larger bench on reference. So there was no occasion for the court, or there is no requirement for the court to deal with the statute, whether it is procedural or substantive. There was a law in force which was interpreted by the Supreme Court in a particular manner, and there was second school of thought, another bench of the co-ordinate bench of the same Supreme Court had a different version. So between Dhanama's case and Prahlad Dev's case, there was a difference of opinion. So the Supreme Court thought fit of referring the matter to a larger bench. The larger bench was constituted and they declared the law in Vinita Sharma's case. So the change of law or change in law that made the trial court to refuse equal share to the daughter has become no more a good law after the advent of the judgment of the Supreme Court in Vinita Sharma's case. So the Supreme Court says in Prashanta Kumar's case that the change in law should be applied in a suit for partition, because a suit for partition attains finality only when a final degree is passed. In Prashanta Kumar's case, it was only an appeal against preliminary degree. No final degree is passed. So the matter was decided in favor of the daughter by giving equal share. And accordingly, the trial court is now called upon to pass a final degree by giving equal share, both in the ancestral property and in the self-acquired property of the father. So the net result of the deliberation of the day is that, as per judgment of the Madras High Court in the year 1902, subsequently followed by the Federal Court in the year 1940, thereafter followed by lots of courts across the country in the year 1966, in the year 1969, in the year 1974, in the year 1985, in the year 2007, and the year 2014, and finally in the year 2023. I can conclude by saying that four things are important. When there is an amendment in the procedural law, the change in law should be applied for pending cases, whether trial or appellate stage. Number two, when there is a provision, it says that the procedural law is amended and it is applicable to pending suits and appeals, comma, the change in law should be applied by the trial court and appellate court. Number 3, when there is a change in the law, thereby a jurisdiction of the courts are taken away and conferred to some other forum outside the civil court, such a change in law should be taken into account, though it is not a procedural law, though it may be a substantive law, to give effect into, because after that, when the law is applied, the courts will have no jurisdiction. Number 4, whether irrespective of the fact that the law is substantive or procedural, when the law is changed by the Supreme Court or by the highest court by means of its fall under Article 141, or when the law is declared by the Supreme Court in a clear term, the change in law that was not in force during the original trial should be applied in the subsequent stage, and the law should be applied by all the courts across the country, whether in the original stage or in the appellate stage, because a suit for partition attains finality only after passing a final degree. So irrespective of the nature of suit, whether it's a partition suit or any other suit, when a law has undergone a change, the change in law should be applied in pending cases unless the suit attains a finality, whether it's a trial stage or appellate stage. This is what I want to deliberate today. And I think I have made the subject matter clearer to the audience. And once again, I thank Mr. Vikas for having given me the opportunity, and I congratulate him for continuing with this noble cause tirelessly and for more than 4 years. And a special salute to the organizers and Mr. Vikas. Thank you, Mr. Vikas.
Thank you, Mr. Raghavan. I know that when we were at the seedling stages, you were one of the person who had given so many resources. And be that as it may, we also chip in as and when we feel that there's some different topic. Only one question has come by a youngster. He says, what is the difference between a substantive law and a procedural law?
See, this is a very basic question. Substantive law is the law that defines the rights of the parties and gives the principles of the law relating to a particular subject. Procedural law is the law which governs the procedure to be followed by the court. For example, Evidence Act, Transfer of Property Act, Contract Act, or can be said to be a substantive law, whereas Code of Civil Procedure and Criminal Procedure can be said to be a procedural law. Some acts are both substantive and procedural. So a substantive law or a provision is the law that defines the rights of the parties for a particular subject matter. And procedural law is the law or the provision that gives procedures to be followed by the courts in administering the substantive law. This is the difference between the substantive law and the procedural law.
I knew that it is rudimentary, but a lot of students, and that's why a student only.
That's good. It's an interesting question that you answer.
Yeah. So thank you, Mr. Raghavan, for sharing your knowledge. And tomorrow, do stay connected with us to understand the facet of Article 15.
Sure.
Aspect of reservation by Dr. Charu Mathur, a lawyer from Supreme Court.
Sure.
Tomorrow at 6 p.m. Thank you.
It will be my pleasure, yes. Thank you.
But I know that it will be a challenge because there's a match also.
Yeah. Thank you. Yeah. Fine.